So here's my free advice. It's non-legal advice, so take it with a grain of salt if you wish. But let's review the orders from last year. I'll explain some easy solutions so that you can fall into compliance with the applicable legislations. And keep in mind that what I'm going to talk about happened last year, so it's probably going to happen again this year. And they do a number of different blitzes throughout the year. New and young worker is certainly not the only one. So in the first part, we'll talk about the charges under the Act. The next video that I'll post next month will be about the charges that relate under the Industrial Regulation 851, and that's the most widely applied workplace regulation in Ontario. So I've got another question for you. Do you know you could be charged under both the Act and a regulation? And that is true, you can be charged under both. Okay? Let's take a look at the orders, and I'll talk about some easy ways to circumvent this and completing your due diligence. These are in order for the fewest orders that they got last year during the new and young workers. So with 141 orders, get your green books out, look up section 8, subsection 6. It reads, by the way, unless otherwise required by a regulation or by an inspector, a health and safety representative, the HSR, shall inspect the physical condition of the workplace at least once a month. Now, my advice to you would be is making sure that the members of the Joint Health and Safety Committee or the HSR inspect the workplace and document their findings. I've always said that to clients: if you do not document it, it's like it did not happen for the ministry. So make sure we document all of our findings during those, and it's proof that you've done it. If we do it and don't write it down or don't document it, we don't have the proof. Essentially, it didn't happen. And also document the date, time, location, and any discussions that took place with workers along the way. If you turn to section 32, this is in part 3 of the Act, section 32.0.6. This is about workplace violence and harassment. Subsection 1 reads, an employer shall, in consultation with the committee and or a health and safety representative, HSR, develop and maintain a written program to implement the policy with respect to workplace harassment. So all employers in Ontario must create a policy regarding workplace harassment, including the definition of harassment, so people understand when they're receiving it or when they're giving it, when they're being harassers. They understand they're not supposed to do that. Give examples of harassment, not particularly name calling and local examples, but other examples that you can find. Actually explain what is not harassment. For instance, a supervisor just asking you to do work is not harassment because you don't like the job. And the steps to take if you are a victim. And finally, must tell the employees about the program and what's going to happen with the sensitive information that they may share with you. Okay, 172 orders were placed under the same section, but subsection 2, and it reads that policies for violence and harassment shall be written in written form. Can't be a verbal policy. A written form and shall be posted in a conspicuous place in the workplace. Conspicuous. So that means standing out so as to be clearly visible. Also attracting notice or attention. That's what conspicuous means. So where would we put it? Well, we would put it in the lunchroom, that's for sure. Employers must communicate the contents of this program, and if I were you, I'd make sure that everyone signs off on that review and that understanding of the policy, and any policy for that matter. Posted on the safety board, like I said, in the lunchroom, in the reception area. You know, the best place to generate a great impression, first impression with the Minister Labour Inspector, is posted inside the lobby so that they can see it there. Make sure it's got a recent date on it, no more than a year old. With 175 orders under the same section 32.0.1, subsection 1, clause C actually reads that an employer shall review policies as often as necessary, but at least annually. So at least as often as necessary usually does mean at least every year. However, there are situations where you might want to review your policy more frequently, and those would be after an incident of violence or harassment takes place, before a court case involving a worker, when the legislation changes is the best time, and also when you open a new office in a new province or territory. They may have different, and they will have different laws slightly about this. Continuing on this topic of violence and harassment, there was 1,429 orders of that 7,000 and change issued regarding violence and harassment, including no policy or program whatsoever. There's no excuses. This is 2006 when that came out. You have to have that. A policy and a program. If you need help with that, let me know. I've got some free resources that you can use. No training or explanation of the program to workers. So all that takes is an inspector asking a worker about the violence and harassment program. If the answer is we don't have one, it's not a good answer. Also, no assessment or a survey took place, as if it did, it would be only once a year. You would do a survey and you would say, ask employers anonymously on a form, have you ever been harassed at work? If so, what did you do? Those sort of questions. Again, I can give you that survey if you connect with me. Under section 25, subsection 2, clause A in the Act, this 25 and 26, as I said earlier, was for the employer. There was 185 orders regarding providing information and instruction. So an employer shall or must absolutely provide instruction and supervision and information to the worker to protect their health and safety. So the information component, the instruction component of this would include training, development of policies, of procedures, safety talks by supervisors, documenting who attended them, and of course testing or quizzing on this knowledge. But for one thing is sure, you got to write this stuff down. When you do things, write it down and you won't get credit for it. It's not sufficient enough just to tell the worker what you want them to do. It has to be done in a written manner. Documented procedures increase consistency and quality anyway, so it lowers incident rates as well. Another thing about this clause, it was information, instruction, and providing supervision for workers. So workers must be provided with effective supervision by people that are competent. So the definition of competency in the Occupational Health and Safety Act for Ontario is a person who knows the job, they can organize the work and its performance. They're familiar with the laws as they apply, the Act and the laws as they apply to the work, and they can identify potential and actual hazards in the workplace. So we'll talk a little bit more about that. I will tell you this, in my experience in training, certifying supervisors in management on this sort of thing, due diligence in the law, it's part B that they usually get caught up in, which is familiar with the law. They don't know what section, that it's 27 in the Act, that's where all their duties are. They don't know that. So that would deem them to be incompetent, because again, that's a full three-part definition. So let's talk about now the definition of the supervisor, which is a person who has charge of a workplace or authority over a worker. So if a group of people are leaving for a day job off-site, and you point to one of the workers and says, hey, I want you to be the supervisor today, or you're in charge, you now have all those duties, not only your own under Section 28 as a worker, but also 27 as the supervisor. The Ministry of Labour does not care what your company calls you if you're a supervisor. If they want to call you a lead hand or a team lead or some nice cushy title that doesn't really reek of supervisor, the ministry doesn't care. It's the action that you take, not your job title. Under Section 8 of the Act, subsection 1, it reads, this is about constructors and about committees and stuff. At a project or a workplace where there is no committee and where the number of workers regularly exceeds 5, so remember I said from 6 and up, the constructor or the employer, whoever, shall cause workers to select one person to be that health and safety representative. So last year, this means that the Ministry of Labour were knocking on doors, small businesses that had less than 20 employees, and they were asking to see the health and safety representative, and there was none set up. And this goes back a long way. Now, the requirement anyway, there still isn't a requirement for any training on this. So it doesn't mean that they shouldn't have training. This person has to do things that the committee does, and without having the training, they wouldn't understand. I'll explain that in a second here.